Okay, hello. Good morning, everyone. Okay. Welcome to the indeterminate sentence. So this is the topic for course unit 13 for finals. So for today's discussion, we're going to discuss what is indeterminate sentence. So as we all know, indeterminate sentence is the law that we use in having for parole. So what is indeterminate sentence ba? So indeterminate sentence is a sentence with a minimum term and a maximum term. Ibig sabihin, hindi siya definite, which the court is mandated to impose for the benefit of a guilty person who is not disqualified. So it applies both a violation of revised penal code and special laws. So whether your violation is made from RAs or yung mga special laws natin, it is applicable. So, of course, syempre, applicable siya sa revised penal code, yung mga articles. So this was created by the virtue of Act 4103, which is further amended by the law of Act 4225 and Republic Act 4203 on June 19, 1965. So it is an act to provide an indeterminate sentence and parole, yan, for all the persons convicted of certain crimes by the Court of the Philippine Islands. So therefore, there are just certain crimes na applicable po ang ating indeterminate sentence law. So this was to create a board of indeterminate sentence and to provide fines therefore and for other purposes. Indeterminate sentence and parole were introduced our penal correctional system on December 5, 1933. So, ganun pa lang kaaga, meron na tayong islaw na tinatawag. So, ano ba ang purpose? So, what is the purpose of having indeterminate sentence? The purpose of having indeterminate sentence is to uplift and redeem valuable human material and prevent unnecessary excessive deprivation of personal liberty and economic usefulness. So, nagkakaroon tayo ng indeterminate sentence just to look up where it is, pwede pa siyang ma-revive or hindi. Looking for the prevention of unnecessary and excessive deprivation of personal liberty. Ang tanong, it depends on what? It depends on their behavior. Yan, syempre. Mapapasok po ba yung GCT8? Yes, pwede. It could be. Behavior, physical, mental, and moral records as a prisoner. So, the indeterminate sentence removes the length of sentence from jurisdiction of the court. Ibig sabihin, yung length sentence na yan, ito yung fixed definition na binibigay ng court. So, inalis niya yan. Kasi nga, depende doon sa kanyang behavior, physical, mental, and moral records as a prisoner. So, passing the authority to a parole board of several members who are ideally supposed to be experienced students of human behavior and rehabilitation. So, what is the distinction between an indeterminate sentence for a definite determinate sentence? Ano nga ba yung pinagkaiba niya? So, in indeterminate sentence, a sentence imposed for a crime that is not given a definite duration. Ibig sabihin, kapag naparusahan ka ng isang crime, pwede ang parusa mo sabihin nilang 10 years to 15 years. Ganyan. Yun yung tinatawag nating indeterminate sentence. So, the prison term does not state a specific period of time or release or date, but just a range of time. Kasi, there is a possibility na, okay, minimum term lang ang kanyang iserve dahil mabait naman siya. Okay, maximum term ang kanyang iserve dahil pasaway siya or magulo siya or rigorous siya inside the prison. And then we also have the definite or determinate sentence. Ito naman ang kabaliktaran ni indeterminate sentence. It means they are definite. A sentence of confinement for a specific minimum period is specified by statute. So, the period fixed by the statute is not negotiable. Okay? So, a convicted person could serve more than the determinate sentence, but not less. So, actual limits of determinate sentence are determined at the time the sentence is imposed. So, definite or determinate sentence, for example, sabi niya, 6 years ka makukulong, then 6 years ka makukulong. So, walang possibility na bumaba yan. Pero, may possibility na mas tumagal yan. So, that is the definite or determinate sentence. So, what are the objectives of ISLAW or the indeterminate sentence law? The objectives of the law are to avoid prolonged imprisonment of convicts resulting in economic wastefulness. Diba? Sobrang matagal mo lang na maikukulong isang tao, tapos dagdag na lang siya sa pakain ng lipunan. Diba? Ganyan. So, to decongest the jails also, diba, habang tumatagal kasi dumadami ang ating mga sa kulungan. So, this is a one way of solution, giving solution to that problem. We can decongest the jails by having the convict serve their sentence outside of prison or kung mag-undergo nga sila ng parole, pardon, ganyan. So, to save the government of the expenses, of course, syempre, necessary to maintain these prisoners in confinement, to promote reformation of the prisoner by having him under the supervision of parole officer. Yun ang mga tinatawag nating purpose or objectives of the indeterminate sentence of law. Kung tutusin, you're just di ba? We are hitting two birds in one stone kasi nasa-solve mo na yung economic problem ng Philippines when it comes to the money that we use on the prisoners. Also, we are decongesting at the same time yung ating yung mga prisons or yung mga jails, diba? Also, diba, we can reform naman kasi or rehabilitate. Kaya nga meron tayong community corrections, diba? Sa mga gantong mga prisons, diba? To rehabilitate or to reform outside the jail together with their family and doing their community service. Tanong, why is law is mandatory? So, in the application of indeterminate sentence law, the judge will get the maximum penalty and likewise the minimum penalty. If the accused was already able to serve the minimum term of his indeterminate sentence, and upon approval of the board, the accused now becomes eligible for parole. So, yun ang nangyayari. For example, okay, you are being sentenced for, sabihin natin, 10 years to 15 years. So, therefore, 10 years, that is your minimum term, and then, ang maximum term mo is 15 years. So, wala tayong tawag dito, fix. Di natin alam kailan ka lalabas. So, ang rule naman sa atin, basta daw okay na tayo, okay, kapag na-serve mo na ang minimum term, sabi nga natin sa parole, you cannot be given a parole unless you have to serve the minimum sentence. So, law is always favorable to the accused. So, what are the instances when indeterminate sentence law is not applicable? So, as we discussed a while ago, law is just applicable for certain crimes. So, therefore, there are crimes na hindi po siya applicable. It is a basic law that application of the indeterminate sentence law is mandatory except only in the following cases. So, what are those cases? Persons convicted of offenses punishable by death or life imprisonment. Yan, bawal po sila yan. Those convicted of treason, conspiracy, or proposal to commit treason under Article 114 and 115 of the Revised Penal Code. Those also convicted of misprision of treason, rebellion, sedition, or espionage. Those convicted of piracy. Yan. Those who are habitual delinquents. Ano ba ang ibig sabihin ng habitual delinquents? Ibig sabihin, paulit-ulit na lang sa kulungan. Diba? Those who escape from confinement and those who evaded their sentence. Ito yung mga tumakas, escapee. Okay? Those who violated the terms of conditional pardon granted to them by the chief executive. Bawal din po. Those whose maximum period of imprisonment does not exceed 1 year. Therefore, syempre, hindi mo na kailangan ganyan pa islaw kasi di naman nag-exceed ng 1 year ang pagkakasala mo. So, those who are already serving final judgment upon the approval of islaw, so yun, itong number na to, applicable siya nung ginagawa pa yung law na to. So, those sentenced to destierro or suspension. So, kapag yan yung mga kaso mo or violation mo, therefore, hindi po ikaw pwedeng mag-apply ng islaw or hindi siya nagiging mandatory sa inyo. So, what are the factors considered ba in granting parole to an offender with an indeterminate sentence? So, the original recommendation of sentencing judge and prosecutor. So, the length of time of offender has served the conviction to date. Ayan. Ano pa? The offender's entire criminal history. So, again, these are the following things that we need to consider in granting parole or an indeterminate sentence to a offender. Number 1, sabi niya, this is just an original recommendation from the judge. And then, the length of time has served the conviction to date. And any aggravating or mitigating factors or circumstances relative to the crime conviction. The offenders, of course, entire criminal history, di ba? Pina-background check muna nila. and all available information from the victim or the victim's family to include or comment on the impact of the crime, concerns about the offender's potential release, and request for conditions if the offender is released. Yan. So, isa rin sa mga titingnan nila is yung consent ng ating victim. Whether, kaano ba yung impact of crime nila? Kung pwede ba talagang ibigay ang islaw sa ating criminal. So, ano pa? Ito pa. Participation in refusal to participate in available programs or resources designed to assist an offender in reducing the risk or re-offense. Hindi siya sumasali niyan. The risk of public safety. Siyempre, kapag alam natin naman na dangerous type of person, so therefore, it's better na ikulong na lang yun sa loob. Serious and repetitive disciplinary infractions during incarceration. Ayan, habang nakulong siya, imbis na nagpapagood point siya, ayan, puro siya repetitive disciplinary infractions. Ayan. Evidence of an inmate's continuing intent or propensity to engage in illegal activity. Examples are victims' harassment, ayan, criminal conduct while incarcerated, use of illegal substances habang nakakulong. Statements or declarations by the offender that he or she intends to re-offend or does not intend to comply with the conditions of parole. Ayan, syempre, kapag nahanapan ka ng ganyan na, ay, hindi ko naman siseryosoin yung parole ko, ganyan. So, hindi talaga ibibigay yan. Evidence that an inmate presents a substantial danger to the community if released. This is just the same, just like the risk to public safety. So, ito sa 11 naman, there is a proof, there is an evidence. So, what are the rules in determining the maximum and minimum terms of the indeterminate sentence ba? So, if the crime is violation of revised penal code, we have the maximum term and minimum term. So, the maximum term is that which could be properly imposed under revised penal code considering the aggravating and mitigating circumstances. Ito na yung pinaka-maximum. For example nga, 10 to 15 years, 15 years ang maximum. So, ano naman yung minimum term? So, this is the range of the penalty 1 degree lower than the prescribed of revised penal code without considering the circumstances of it. Okay. Outline of the rules and provisions of laws as basis for fixing the indeterminate sentence. So, under Article 64 of the RPC, these are the rules for the applications of penalties which contains 3 periods. Ito. No aggravating and no mitigating, therefore, it should be given a medium period. Only mitigating, then minimum period. Only aggravating, that is a maximum period. So, where there are aggravating and mitigating, the court shall offset of one class against the other according to their relative weight. So, kapag merong aggravating and mitigating, therefore, titignan nilang mabuti kung saan sila mag-meet sa gitna. 2 or more mitigating and no aggravating, penalty next lower is given to the period applicable according to the number and natures of such circumstances. So, pero kapag naman mas madami ang mitigating at walang aggravating, therefore, next lower period ang ibibigay sa kanya. No penalty greater than the maximum period of the penalty prescribed by the law shall be imposed. So, no matter how many aggravating circumstances are present, still, the greater or the maximum period lang po ng ating batas na sinasabing ganun ng penalty niya, yun lang ang ibibigay mo sa kanya. Then, the court shall determine the extent of the penalty within the limits of each period. So, the court shall determine that extent of the penalty according to the number and nature of the aggravating and mitigating circumstances and the greater and lesser extent of the evil produced by the crime. So, ang korte po ang nag-decide kung gaano siya katagal dun sa place na yon or gaano lang siya mag-serve ng kanyang kulungan. So, what are the rules in determining the maximum and minimum terms of indeterminate sentence? If the crime is violation of special law. Kanina naman ang pinag-usapan natin, di ba? If the crime is violation of revised penal code. Ito naman, what if it is a crime of violation of special law? So, without adopting the nomenclature of penalties under the revised penal code, there are both minimum and maximum terms shall be fixed by the court within the range prescribed by the special law. So, for example, yung sa drugs natin, ayan, sabi niya, di ba, 12 years to 20 years. So, yun na yun. So, maximum term not higher than the maximum period of the penalty fixed by the special law. And then, minimum term not lower than the minimum period of the penalty fixed by the special law. So, yung mga special laws kasi natin, talagang nakafix na yung mga ano yan, yung mga tawag dito, the number of years kung or kailan ka magiging incarcerated. So therefore, this is fixed na agad. Hindi na kailangan pa mag-ano ni judge. Okay? So, if the crime is committed in a complex felony, what is a complex felony or complex crime? Therefore, there is two crimes. So, in complex crimes, the penalty is imposable as always the penalty of the graver offense to be imposed in its maximum period, regardless of the presence of the any mitigating or aggravating circumstances. Ano bang ibig sabihin ng complex crime? These are at least two offenses that are committed and one or some of the offense are decided to commit the other. All the offenses are punishable under the same statute. Ang complex crime, these are the two crimes committed in one single incident, or even pwedeng this is a two crime or at least two offenses wherein it happens that this is necessary, or after committing a crime, gumawa ka ng another crime. For example, robbery. So, ang una nagnakaw ka lang, that is your intention. Pero dahil nahuli ka ng may-ari, pinatay mo na rin yung may-ari. Nagkandak ka na rin ng homicide. So, therefore, that is a complex crime. Ma'am, ang tanong, kanino po susundan? Di ba po, iba ang penalty kapag robbery, iba ang penalty kapag murder. According to this law, okay, if the crime committed is a complex felony or complex crime, therefore, ang ibibigay nating penalty is the graver offense. So, given that example, robbery and murder, so what is the most or parang mas graver penalty? And that is murder. So, these are the applications of indeterminate sentence law in the complex crimes where there are mitigating circumstances. So, there are two rules to take note of, the Rama rule and the Gonzalez rule. So, ano bang nangyari kay Rama rule? So, the Rama rule is the rule that provides that the basis for going down by 1 degree if the penalty is a prison mayor of maximum, and 1 degree lower is prison mayor medium. So, hence, based on the indeterminate sentence law, the duration of prison mayor is minimum to medium. Kapag binigay sa kanya is prison mayor. That is Rama rule. Next, how about the Gonzalez rule? So, the rule provides that the basis of going down by 1 degree is to go down 1 whole degree. An example above, 1 degree lower is now prison correctional. And the duration based on determined sentence law is arresto mayor to prison correctional. So, note, the correct rule that we are adopting now is the Rama rule. So, this is applied to special aggravating circumstances, quasi-recidivism, and error in personality. Paano ba yung kay Rama rule? Basis for going down by 1 degree is if the penalty is prison mayor maximum. Then 1 degree lower is prison mayor medium. Hence, the indeterminate sentence law of duration is prison mayor or minimum to medium. Pag sinabing mitigating circumstances, alam ko pinag-aaralan nyo natin sa law, these are the circumstances wherein mas pinapababa yung kanyang sentence. So, what is the distinction between degrees of the penalty from the period of penalty? When we say degree, this is the one entire penalty, one whole penalty or one unit of the penalties enumerated in the graduated scales provided in Article 71 of the RPC. Each of the penalties of reclusion perpetua, reclusion temporal, prison mayor, enumerated therein is a degree. So, that is a degree. How about period naman? Period is one of 3 options, pwedeng minimum, medium, and maximum of a divisible penalty. Ano po yun, ma'am? Isa pa ha. Pag sinabi natin degree, ito yung mga prison mayor, prison correctional, na pinag-aaralan nyo, di ba? Arresto mayor, ayan. Bilang ating mga degree. Yung mga period, meron siyang minimum, medium, and maximum. Ma'am, saan natin mahanap yan? Makita niyo sa graduated scales ng ating Article 71 of Revised Penal Code, which is pinag-aaralan nyo naman ngayon. So, the scales and ranges of penalties from which to take a penalty lower or higher by 1 or more degrees. So, that, take note, in the view of that penalty under RA 1946, this is no longer applicable, diba? It included the scale of penalties under Article 71 of the Revised Penal Code. Reclusion perpetua means this is the 20 years, 1 day to 40 years. So, ito lang yun, yung parang degree. Pag sinabi natin reclusion perpetua, diba? 20 years to 40 years. Diba? After serving 30 years, he may be pardoned, not a divisible penalty. How about reclusion temporal? Ito yung 12 years, 1 day to 20 years. Question. Ma'am, what is the purpose of that 1 day? So, therefore, meron tayong separation. Yun talaga ang tawag dito, ang purpose, bakit merong 1 day lagi sa gitna? Tignan nyo, 1 day to 40 years. That is separation period. So, minimum, tignan nyo yung minimum, medium, and maximum ng reclusion temporal. Minimum niya, 12 years, 1 day to 14 years and 8 months. The medium niya is 14, 8 months, 1 day to 17 years and 4 months. Kapag sa maximum niya is 17 years, 4 months, and 1 day to 20 years. So, that is minimum, medium, and maximum. How about prison mayor? 6 years and 1 day to 12 years. Minimum, this is the 6 years and 1 day to 8 years. Medium niya, 8 years to 10 years. Ang maximum niya, 10 years, 1 day to 12 years. Note, 1 degree lower is prison correctional. So, 2 degrees lower is arresto mayor. Yan. So, prison correctional and destierro, 6 months and 1 day to 6 years. Minimum of 6 months to 1 day to 2 years and 4 months. So, medium naman niya is 2 years, 4 months, and 1 day. And 2 months. And the maximum period of this is, syempre, abot siya 6 years. 4 years, 2 months, 1 day to 6 years. Note, 1 degree lower than prison correctional is arresto mayor. 2 degree lower under the prison correctional is destierro. And 1 degree lower than destierro is arresto menor na. And 2 degrees lower than destierro is fine. Arresto mayor. Ayan. Minimum, medium, and maximum. Minimum 1 month to 2 months. Medium 2 months to 4 months. And maximum is 4 months to 6 months. So, 4 steps on how to fix the indeterminate sentence. So, these are just the durations of penalties when we're talking about the minimum, medium, and maximum. So, these are the degrees. So, reclusion perpetua, reclusion temporal, ang tawag dyan, degrees. And then, this is the minimum, medium, and maximum. These are what we call period. Okay. What are the 4 steps on how to fix the indeterminate sentence? Determine the crime committed and the penalty imposed by the revised penal code. Next, fix the proper degree by determining if Article 64, paragraph 5, two or more mitigating and aggravating ba. Article 68 if it is minor, and Article 69 incomplete self-defense under the revised penal code are present. Lower the penalty by degree or degrees. Next, fix the minimum penalty by lowering the penalty by 1 degree from the penalty imposable or from the proper degree if step number 2 is applicable. This is the basis of the minimum without reference to any particular period. We also have fixed the maximum period by going 1 degree higher to a minimum and look for remaining mitigating or aggravating circumstances. So, if any, apply the rules on the offsetting in Article 64 of the revised penal code. So, ito naman yung pinag-usapan natin ito, pag-aaralan nyo sa law. Sa Law 1, Book 1. So, Article 68 of the RPC, penalty to be imposed upon a person under 18 years of age. Diba? Wala pa siya sa ating majority age or maturity age. So, when the offender is a minor under 18 years and his case is one coming under the provisions of the paragraphs next to the last of Article 80 of this code, the following rules shall be observed. So, upon a person under 15 but over 9 years of age who is not exempted from liability by reason of the court having declared that he acted with discernment, alam din ginagawa niya, therefore, a discretionary penalty shall be imposed but always lower by 2 degrees. Siyempre, at least than that prescribed of the crime which he committed. So, for example, ang kanyang penalty is, sabihin na natin, prison mayor. So, kung minor siya, bibigyan na lang siya ng arresto mayor. So, upon a person over 15 and under 18 years of age, the penalty next lower shall be applied but always in the proper period. Pag naman siya, basta kapag ang age niya is under 15 but over 9 years of age, therefore lower siya ng 2 degrees. Pero kung kanwari under 18 years of age, pero above 15 na siya, therefore, it is the age penalty. One lower lang. So, the next lower lang yung bibigay sa kanya. Mas syempre, pag mas bata, mas mababa ang ibibigay na penalty. So, Article 69 of the RPC, penalty to impose when the crime committed is not wholly excusable. So, a penalty of lower by 1 or 2 degrees than that prescribed by law shall be imposed if the deed is not wholly excusable by reason, okay, of the lack of some condition required to justify the same or to exempt from criminal liability. So, in the several cases mentioned of Article 11 and 12, provided that the majority of such conditions be present. So, the court shall impose the penalty in the period which is deemed proper in the view of number and nature of the conditions of exemption present or lacking. Kapag not wholly excusable, di ba meron tayong mga crimes na tinatawag nating justifying and exempting. Kapag justifying, di ba, both criminally and civilly liable, wala siyang kaso. Pero pag kanwari, ang nag-fall out lang siya sa ating tinatawag na exempting. Therefore, pero hindi pa not wholly excusable. Yan, ganyan na magiging rules natin. So, ibig sabihin, mas maglo-lower lang siya ng kahit pa paano lang naman. So, that's it. That is the course unit 13 of this final. So, if you have any questions after this discussion, kindly message me or just raise this in our synchronous session. So, after you have watched and listened to this discussion, please proceed to the recorded discussion of course unit 14. Okay, thank you.